In today's video, we'll be discussing some of the most common estate planning questions that I hear. We're going to be talking about what is an estate, what is probate, do you need a will or a trust? So stay tuned and we're going to learn some of the basics of estate planning. Hi, I'm attorney Rilus Dana. I practice law in Arizona and California in the areas of probate and estate planning. In helping clients to this area, we also deal with real estate quite often. Okay, so when I first meet with the client, we ask them to fill out this personal inventory because we need to know, who they are, if they have any kids, how old the kids are, some information about the kids, and then what assets they're planning for. And then we can get into the type of plan that's right. So this is some of the materials that I like to use in my first meeting. First, what is an estate? So in estate planning, what is an estate? Are you talking about a big house? I mean, sometimes estate is used that way. In the estate planning, what we're talking about is everything a person owns, whether alive or dead. So that's what an estate is, everything a person owns, alive or dead. A last will and testament is a document that controls the estate. It designates who the beneficiaries will be, who the guardian of minor children will be, and who the personal representative will be that's in charge of the estate. After a person passes away, to activate the last will and testament, probate is required to appoint the personal representative and guardian. So this scenario here shows more about probate, what probate is. So this couple, this is our friends, Mr. and Mrs. Estate. In this scenario, they have a house together. She has a bank account in her name, a life insurance account that names him as the beneficiary. She passes away. He collects the life insurance because he's a beneficiary, so that avoids probate. His house was already on the name of the title as joint tenants with rights of survivorship, so that avoided probate. But this bank account is just in her name. So even though there's a will that names him to be in charge as a personal representative and the beneficiary, if he walks into the bank, they're going to say they need a court order. So the will itself or the will alone is not enough to collect that account. So probate is a process to appoint the personal representative. There's lots of steps. It takes lots of time and can be expensive. So therefore, most people try to avoid probate by doing some planning. So I want to show you the type of trust that I recommend for most married couple. We call this the continuation trust. All right, so they have a house, bank accounts, some IRAs, life insurance. So a trust is a legal document. The persons that make the trust are called, well, first they name the beneficiaries and when and how they'll receive it, and they'll name the successor trustee in a trust. The persons that create the trust are called the trustor. So I use this briefcase. It's like the bosses. Briefcase equals boss. That's the trustor. The trustee manages. That's this green bookkeeper visor for the manager or trustee of the trust. And this hand represents the beneficiaries. So Mr. and Mrs. Estate, they make the trust, they manage it for the benefit of themselves. So they're all the parties. Unlocked, meaning revocable. They can make changes to the trust whenever they want. So they'll create a trust, then they'll transfer their house in there, their bank account into the trust. Retirement accounts, we look at the beneficiaries. We update the beneficiaries to control retirement accounts, and same thing with life insurance. Usually it's controlled by the beneficiaries. All right, Mr. Estate's already gone in this scenario. He passes away. So she has her life insurance still. His life insurance, the beneficiary was actually the trust. That's how I like to do it. She's still controlling the trust. So she receives the life insurance just inside of the trust. She's still the trustor, trustee, and the beneficiary, and it's still revocable. So full control to the surviving spouse with this continuation trust. The retirement accounts, you'll name your spouse as the beneficiary. So that will roll over. So this is what it would look like after one spouse passes away. The other spouse collects everything and has full control. Now, if time goes on and the surviving spouse is incapacitated, another advantage of the trust is the successor trustee can step in and manage things for the trust creator. We call this process a living trust administration. Sometimes it's done voluntarily by people they realize they're no longer able to manage their affairs, or they just simply don't want to do it anymore. Other times it's done by two doctors is the standard that I build into my documents. I say two doctors' letters will activate the power of the successor trustee. All right, so the second trust creator passes away. Now the trust is locked or irrevocable. Mr. and Mrs. Estate, the trust creators, they're the only ones that can make changes to this trust. So now that they're gone, their wishes are locked in and it's irrevocable. IRAs are going to go to whoever's named as the beneficiaries there. Taxable, meaning subject to income tax. Life insurance, whoever the beneficiary is. So if the trust is the beneficiary, those proceeds get added to the trust banking account. So the terms of this trust say 1/3 at age 20, half at 25, and the balance at age 30. So here's what that would look like. This oldest child, who's actually the trustee as well, is 33. So they're going to get all of their share outright, the oldest child. 21-year-old, so 2/3 of his share is going to be held in trust, and 1/3, since he's over 20, he'll receive 1/3 outright. This 18-year-old, all of her share is going to be held in trust for her. So that's the continuation trust. For most married couples, that's typically what we're doing. So if this was your first initial consultation, I'd probably show you that presentation and ask your specific questions. And then let me show you what's included in our package. Because even though we're doing a trust, you still need a last will and testament. So this is what we call our welcome packet. And it shows the timeline. I like to refer to this a lot as well. Make sure people understand where we're going, how long it's going to take, and all of that. So we call the first meeting the personal family legal session. And I'd probably show all that information, figure out that people need a trust. And then before I show them the fees, I like to show this timeline. So if they're ready to get started, I'll collect a deposit of half once I show them the fees. And then we'll start designing their plan. We'll go over who the decision makers are going to be. And then after the meeting, they'll have a chance to review that information and then approve it. And after they approve, they'll schedule their next attorney review meeting. So this is where we get together. It works really good as a Zoom, or some clients prefer to do it in real life. But the point of this meeting is to review everything and finalize everything, get it ready for the signing. At the signing meeting, they'll sign everything, and then we give instructions on how to transfer real estate, bank accounts, update life insurance, retirement accounts, and all the final steps that need to be done so the plan will work. We give all the documents in an original binder, like I got one back there, kind of in the frame. And then we scan everything and provide what we call a digital vault. We pay for the license for this software, so they can access the digital copies and decide who else can see this. Now, in addition to a trust, our trust package also includes everything in this will package. The main thing is attorney to design the plan. When you're working with a professional like myself, you get someone to take you through all of this process, and you get the advice and feedback to help you design a plan. The last will and testament still part of that. That's going to control your personal property, furniture, jewelry, who gets the Beanie Baby collection, all that stuff. Healthcare power of attorney, including mental health care provision and living will. Financial power of attorney. Trust package includes all of that, plus the trust. This digital asset language, this is something I'm proud of. This is important because less stuff comes on paper these days. So when I started in this business about 20 years ago as a law clerk in my dad's firm, I became aware of this issue. we'd get calls from the kids after someone passes, and they would say, how do we figure out what they owned? I found this 20-year-old trust, but I don't see any financial information. So what do I do? Well, number one, as part of our plans, we're going to help you leave better information. So that's not your kids, but this digital asset language, this allows a trustee to be able to request information about the accounts. So the information about the accounts is a digital asset. So we allow the trustee to access that basic information. And then the digital asset trust, we get some more specific instructions. For email, what I recommend is we list your emails and we allow the successor trustee to request a list of emails received for the last 12 months. So they can't read your messages. You're not sharing the password. They can just get a list of emails received. So back in the day when everything was on paper and we couldn't figure out what someone owned, we would start getting their mail. We would see what bank statements show up. So this gives us the modern way to do that. The other thing is if you're storing anything, oops, I'll scroll down here. If you're storing anything else electronically, like photos and videos is the other thing I'm concerned of mainly, we can give instructions for those. So this is a digital asset inventory and checklist. A lot of people don't realize they have digital assets until that first client meeting with us. So I like to give them time to think about other things that they may have. So inventory, meaning what things do they care about? 2, check for an online tool, meaning does that account provide a way for you to transfer that account? Like Facebook has legacy settings. Google has what's called inactive account manager. So I want you to check and see if there's something like that that's adequate. For accounts that lack an adequate online tool, then you can give instructions in your digital asset trust. So for me, I mentioned my YouTube channels that I put family videos of my kids on and my Google Drive. I mentioned that in my digital asset trust. I don't want to name anyone right now as my inactive account manager, but I do want to make sure those things go to my kids. So I mentioned it in my digital asset trust. So the whole package for a married couple, about $3,000, a little over $3,000. And then it could go up from there if there's other add-ons and other specific things that are needed. And then the way your meeting would go, if you're ready to get started, we can get started with a deposit, and then we would go right back into here, into this Maat Legal software, and start designing your plan. So this is where I start asking you questions like, what should we name your trust? Who should the successor trustees be? At what ages should the beneficiaries get it? And all of that good stuff. This is also where you'll get a chance to confirm the details. So after we finish the meeting and I've collected all of this, you'll have a chance to go through this again and see if you still like the choices that you've made. Hopefully you found this video helpful. Let me know what other topics that you'd like to hear about. Let me know if you have any other estate planning questions. Have a great day. Also, I'll point out that we have a link to a free will. So I've provided instructions on how to do a free handwritten, also known as a holographic will. So make sure you get that done today. If you don't have one, I want to make it really easy so you can knock that out and make sure your family's protected.